It's a pretty good game show, don't you think? Hmm? Do you want me to go get your stick? Do you want your stick? Huh? Do you want your stick? Huh? Hey, Days. What are you going to do? What are you going to do, Days? Not too interesting with you just laying there like that. Oh, you're going to go to sleep again, huh? Oh, well. How you doing, honey? How are you this morning? I see a good girl. Oh, she got a bite. Oh, she's got a bite. Yeah, what you doing? What you doing, Days? What you doing? Huh? What? What? Can you speak to Mom? Huh? Can you speak? No? Oh, she got another bite. Hi. How are you this morning? Huh? Oh. Big yawn, huh? Okay. All gone. Look at Daisy Mae. She just got up. Hi there, Daisy. Did you have a good sleep last night? Hmm? Did you have a good sleep? Did you? Hmm? Don't tell John you were on the bed. Oh, no. Is that your favorite spot, Days? Hmm? Is that your favorite spot? Just relaxing. Yeah.
We're getting into the final stages of a about $70 million rebuild to get it back into shape. And, so I was down here today filing 2 motions in a district court where once again the nation's corporate attorneys for banks are trying to take me to court to hold me liable for their criminal misconduct. And this action is filed in the District Court for District of Maryland, Prince George's County, and it's Branch Banking and Trust Company versus George and Patricia McDermott. And I filed 2 motions with the court today. The first motion I filed with the court is case number 05020018711-2007. And its first motion I filed was a motion to join additional parties, and I'm going to read the motion into the record. For the reasons stated briefly below, defendant George E. McDermott and Patricia McDermott, the McDermotts, move the court pursuant to Maryland Rule 3-330C and Rule 3-311 for an order allowing to join additional parties in support of their request state as follows. This action is paragraph 1, this action is inextricably intertwined with pleadings pending appeal. Appeal number 106, September term 2006. That's a typo. It is 2006, not 2004. McDermott Bowie versus et al. Versus argued solely by one party. See the annexed exhibit. And this is, that exhibit is Exhibit A. And that's the, I've already supplied that to the court. A transcript of a 1/2 hour of oral arguments before the court, June 26th, in the Maryland Court of Special Appeals. As you'll see by other videos, this case is, the bank would like the court to believe that this is a simple case of failure to pay a debt, but in fact it's a multi-million-dollar counter lawsuit against the bank and its officers and agents for destroying my credit, stealing my business, and helping insiders to defeat the rule of law. So, Exhibit A, a notice to defend. Chief Judge Murphy stated he was shocked and profoundly concerned with the fact that the opponents there, one of whom is plaintiff in this action, were misleading the court as to the legal standing and their illusionary right to assert ownership of a business. For this court's convenience, annexed are copies of documents exemplifying the nature and underlying litigation and the nature of the McDermott's counterclaim against BB&T Bank and additional parties. And these additional parties are. And so what I've done is I've filed a notice with the court as you're supposed to. They've sued me. Now I have the right to countersue them and bring in third-party cross-claimants that the bank can go against, who are really the ones who are liable for this debt, not myself, as I've asserted for years. But first you have to file the proper motions with the court. I'm furnishing the court with Exhibit B, a unanimous consent by the directors of a meeting signed September 2nd, 1994 by unauthorized parties transferring the McDermott's business account for Crystal Skates of Maryland, Inc. and also Crystal Skates Limited Partnership with First Virginia Bank, successor to BB&T, and succeeded by Farmers Bank and later succeeded by BB&T. The second document under Exhibit C is a copy of a exemplary partnership check authorizing payment by First Virginia Bank and showing the signature of Patricia McDermott, who signed on the account. And these are the two exhibits. Here's Exhibit B. Now what happened is the bank allowed these gangsters to come in and to take over my checking account without checking with the corporate attorney or anybody else based on this forged document. And the consequences of that is the loss of at least $26 million or more by myself and my partners because of the bank's reckless misconduct. And here is the actual checks which show First Virginia Bank and show that my wife was and I were both the only legal signers on this note. Okay, let's go back to the motion. Exhibit number D is a letter from Don Noble, who was our corporate attorney, who we had no idea at the time was actually a representative from the Saperstein Crime Syndicate. working against the best interest of the partnership and the partners of the partnership. It's a partnerships council dated September 16, 1994, 10 days after they took over the checking account. And in the letter, the counsel for the purported officers see Exhibit B, stating that the latter had no authority to control the affairs of Crystal Skate. And what he said in his letter was that their actions were illegal and they had no authority. As of September 16th, they weren't even incorporated, so any transactions they took place were a fraud by them and their attorneys. And then we go to the Exhibit D, which is a unfulfilled authorized agreement. Well, let's see. Okay, here's the Exhibit D. C, rather. And as you see, it's from Noble and Lipstein, the gangsters' attorneys, who were trying to cover up their criminal misconduct. And this has already been entered into the case in 95-13288 as evidence, and it cannot be refuted by the judge. And this is exactly what it says on page 2 of that agreement. Parker and Bowie have no authority to control in any way, respect the internal affairs of Crystal Skates Firm. They are, in fact, themselves destroying the goodwill of sellers and suppliers, suppliers, and accountants. Parker and Bowie have repeatedly accused us that prompt action should be taken to satisfy the conditions of closing of the August 9th agreement. We are certainly no further along than we were on August 9th, and this is because they came in and took, with the help of the bank, took control of the checking account, stopped paying all the creditors, and this is all well documented in the court cases cited. So let's move back, and then we'll go to the final one. We've got Exhibit D, an unauthorized August 9th agreement, which has already been put into many courts and shows the perjurious intent of the bank's agents working with the Saperstein crime syndicate. And then Exhibit E is a letter from Tamara Fine, Assistant U.S. Attorney in Baltimore, dated December 16, 1998. The latter confirms that the McDermotts have been contesting the BB&T in concert with others action for the past decade. Now it's 2 decades and counting. So move on to paragraph 2. In view of the above, joiners of the following parties are required: BB&T Bank as a defendant in a counterclaim, Jacob C. Davis, Esquire, as a defendant in a counterclaim, Peter Parker as a defendant in a counterclaim, Wayne A. Bowie as a defendant in a counterclaim, and Kansas Associates and their lawyers, the latter unnamed defendants, should, and the reason it's the latter unnamed, in 14 years as of right now, 14 years, I've never been allowed discovery to find out exactly who all the attorneys were and how corrupt the system is, because this court back here is covered up for. Should this motion be filed outside of the time allowed by Maryland Rule 3-331D, the McDermotts respectfully request a non-proton order, a brief extension of time to make the motion timely. And I have a copy of the court docket today, which shows that it was filed timely. So that's this motion. And then I filed a second motion, a motion for stay and pending a disposition of the court, and this is the exact same caption, BB&T versus McDermott. And it's a motion for stay, and this is also filed today, the 13th day of August 2007. For the reasons briefly stated below, defendant George E. McDermott, Patricia May McDermott, the McDermotts, moved the court under Maryland Rule 3-331D and Maryland Rule 3-331 for an order staying the action, and in support of their request state the following. As this action is inextricably intertwined with the pending appeal number 106, September term, and it should be 2006, it says 2004, McDermott versus Bowie et al., argued solely by one party, see the annexed Exhibit A, on June 26 before the Maryland Court of Special Appeals. The counterclaim will exceed the monetary jurisdiction of this court under Rule 3-331D, and the monetary claim in a district court is a little over $5,000. I will be seeking a little over almost $4 million in compensatory damages, another $20 million in punitive damages, and another $20 million in exemplary damages based on the willful misconduct and negligence on part of BB&T Bank and its officers, who at the time were fully aware that there was a hostile takeover taking place, having been given loan packages and been made fully aware of the corruption within the parties who they dealt with. They moved ahead, and as a consequence, they have forced myself and my wife into below poverty situation at the present. So now, as it is apparent from the previous annex transcript, so Exhibit A to notice to defend, Chief Justice Murphy was shocked and profoundly concerned with the fact that my opponents, one of whom is plaintiff in this action, were misleading the court as to their legal standing and illusionary right. I assert the ownership of the business, The court's convenience annexed are two copies of the 5 documents exemplifying the nature of the underlying litigation and the McDermott's counterclaim against BB&T and additional parties. These documents it's the same list of documents, and these documents will be, I will file a more complete counterclaim once this matter is moved to the circuit court where it belongs, and hopefully, as argued before the Maryland Court of Appeals, it will be moved to a circuit court outside of Prince George's County. This is our fabulous courthouse. They're rebuilding the building, but I don't think that the judges in this courthouse will ever be able to rebuild the legal standing and stature that this court enjoyed for many years, because it's overwhelmingly become corrupt over the last 20 years, and because of political appointees who have no respect for the law. So these are the pleadings I filed. It's now September 13th, 2007. And as I said before, this is George E. McDermott, citizen journalist, reporting from the land of the scam and the home of the fraud, Prince George's County Circuit Court. God bless, and have a good day. And these programs. Hey, how are you, care for everybody? Okay, well, look out, because this is I just wanted to get a picture. Okay, let's move on inside. This beautiful home. I don't know how they managed to keep it.
You don't open this. No, we close it because it's getting full of dust.
Oh, yeah.
And so I said, well, when we have someone who's actually going to play it.
And that's Suzanne. Yeah, you just open this a little bit and you get a little sound. Suzanne is a concert pianist. She was.
I'll fold it, Suzanne.
Yeah, okay, hold that because I.
Well, no such thing as one. Beautiful home. I understand you offered it to, at one time it was offered up to the Clintons too.
Well, you can see her unsolicited comments that she wrote in my guest book at the time, and they were so beautiful that I framed them so they're public.
No, she did it on the people of the United States.
Yes, indeed. You're right. I couldn't believe it. We just couldn't get even an apology, a retraction from her for what she did. Her counsel did, and she didn't disavow it.
Yeah.
to call the decent police. You know that.
Thank you so much. Thank you so much. Isn't she grand?
Oh, fantastic.
I haven't really played her. Here you go, Suzanne.
Isn't this gorgeous?
Yeah.
This is lovely. This is.
You know,
This is- this
actually,
is-
who is this? Yours? We sat out there with
Okay.
Madam Clinton when
Okay.
she came house hunting here in
Right.
1999, and we served.
You want to do a little interview out there?
It doesn't really happen.
Oh.
I just.
This is beautiful.
She loved it out here. We served pink lemonade and cookies at Chelsea and Hillary just loved our place. She said it was.
Oh, I think it'd be a fabulous place to do a. Oh, wow. This is a beautiful piece of property. How they held on to it all these years after all what they were put through.
all of you.
Okay,
Do
well,
you have any aspirations?
We're not
it's on camera. Okay, we're all here. This is
Should
we-
we close this later?
No, that's fine. That's fine.
It might be too.
No,
So we're all here what?
I don't know.
We're all here,
We're all here. We're getting ready.
all present and accounted for.
We want to thank you.
We're all here standing up for what is right.
Yeah.
For
And
justice.
hopefully we can unify and build an organization all together that we can start making a more positive impact.
If every judicial victim across the country realized the importance of collective action, the time has come. The time is overdue.
The time is right now. If you look at the amount of foreclosures that people are facing right now, this is the absolute best time to rally the troops and to get them interested, because the courts are the ones responsible for enforcing these predatory loans that are destroying the fabric of this nation. And the only people who are benefiting are the people in the judicial branch of government and the lawyers.
And I want to add the surrogate courts, what they're doing to our populace, and add to that the guardianship courts.
Well, it's not only
I
a
second
question,
that.
not only a question of economics, it's also a question of life and freedom.
In America.
Liberty. If somebody is going to go to jail for a crime
Elena.
they didn't commit,
Elena, this, by the way, is Elena. This is Ruth Sassower, Elena Sassower's mother, who had to endure all the time that Elena sat in prison in Washington, D.C., falsely framed up by the, and that's the really despicable part. She was actually framed by the acting chairman of the Senate Judiciary Committee, Saxby Chambliss, and anyone who doesn't believe me can go on secretjustice.com. The actual Senate video is on the website. It's been there for years, and it will prove beyond a doubt that the Senate had gaveled its hearing closed. And this new video that's going up on August 9th in front of the U.S. Supreme Court will prove that beyond a reasonable doubt that Elena is fighting to clear her name, to have that tarnished felon name removed from
not
the
a
good
felony,
name.
not a felony. It was a misdemeanor, but that she should have a criminal record is absolute outrage in America, but only